Welcome to today's presentation. My name is Alice Hogue, and I'll be your instructor. Boudreaux called the doctor. He said, "Doctor, man, you got to help me. My wife, she's in labor." And the doctor says, "Now, hold on a minute. Now, is this her first child?" And Boudreaux says, "No, you idiot. This is her husband." Okay, so today we're going to be learning about the joint operating agreement. And you have to pay attention when we're talking about the joint operating agreement. And so let's look at what we're going to cover in the agenda today. We're going to first start off with an introduction or an overview. I want you to have a good working definition of the joint operating agreement. And I want you to understand why we have a joint operating agreement. What are the purposes of the joint operating agreement? And what are the alternatives? There was a very important legal case that really established the need for the joint operating agreement. It was called Earp versus Mid-Continent. And I want to go over that case with you so you'll understand sort of the genesis of how the joint operating agreement came into being. And then from that point on, we're going to look at the model form joint operating agreement. Now, if you've already printed out that sample form, that's going to be a big help to you in this presentation, because you can either follow along in that legal in those legal pages or the joint operating agreement itself, or you can follow along in the slides, or a combination of both. But we are going to go over the general outline of the joint operating agreement, and I want to go into some detail about those individual provisions. And then from there, we'll conclude with any questions that you might have. All right, so let's begin with just a general working definition of the joint operating agreement. The joint operating agreement is an oil and gas contract, and it's governing the joint drilling operation and development of mutually owned wells. So it is for working interest owners. This is the, let me get my pens here. This is what we use when there are more than one owner in an area. So if you have an area where there's a lot of competition going up, and you have different companies that have taken leases in the area, rather than let one company sit there and sink $1 million into a hole, the other companies are going to try to get some support for that agreement. And they're going to say, look, you know, let's do this together. Well, I mean, let's put all of our money. I mean, this is all probably the same reservoir. So let's all form an area, and that's called the contract area. And everyone that has an interest in their area will get a percentage of the production based on the number of leases that they have. So when you enter into a contract to drill that many wells and for that much money, you're going to make sure that you have a contract that covers almost every situation, or attempts to cover almost every situation. That's why the joint operating agreement is so lengthy and the print is so tiny, because we're trying to cover every situation that might arise when we have different oil and gas companies that are drilling the same well. So we start off with this basic definition of a contract, of the joint operating agreement. Now, note that this does not have anything to do with pooling or unitization. We're not pooling the working interest owners. We would be pooling the royalty interest owners, but we're talking about how to govern the oil and gas companies that are also known as the working interest owners, not the royalty owners. So this is not a pooling clause or unitization clause. This is simply an agreement between the oil and gas companies in the area that have an interest in this particular reservoir. Bear with me one second. There. Okay, so it's a method of sharing costs and production among the working interest owners. And it governs the conduct of operations. It says, okay, how are we going to decide where to drill a well? How are we going to decide who contributes what dollar amount to this well? Who decides who's going to pay the royalty payments? who's going to pay the delay rental payments if the lease has a, it must be actually drilling to extend the expiration date. So what it is, it's giving rights and responsibilities to the drilling, to the oil and gas companies that are drilling a certain well. Everyone's going to share in the cost, and everyone's going to share in the profits. And it also covers the responsibilities that they have to the royalty owners. The royalty owners still need to get paid. And so we need to figure out who's going to pay them. Is it going to be every person that owns a lease in the area pays their own royalty owners, or will just the operator pay it and be reimbursed? It also talks about when we drill the first well, if that's successful, who can propose another well, and then how each company decides whether or not they want to participate in that subsequent well. So that's the whole purpose of it. It's really sharing cost of production and allocating responsibilities. Now, a little bit of history about the model form. Before 1956, every company had their own form. But then after this case of, after the case of Earp versus Midcontinent, that's when people started creating their own their own joint operating agreement forms. In 1956, the American Association of Professional Landmen got a committee together, and they created a model form joint operating agreement. Now, this was a huge innovation because when every company had their own separate agreement, can you imagine the negotiation that had to go on? First of all, you had to read and understand what their agreement said, and then you had to see how it was differed from what your company agreement did and said. So it was a lot more research. It was a lot more time consuming. So when the AAPL came out with this model form, it was really kind of revolutionary because now everyone had a basic model form. Everyone understood what was in that form, and you didn't have to go to the trouble of reading what someone else's lawyer wrote, making sense out of that information. You just started with this basic platform. And from there, you negotiated what was going to be modified in the basic contract. So it was a huge improvement over just every company having their own. And this was the model form for almost 20 years. And in 1977, there were a number of issues that came up as a result of the 1956. You can imagine over time things changed. And so in 1977, the AAPL again got together and had another committee formed, and they made a major revision to the joint operating agreement. That's the 1977 agreement. In 1982, there was another revision, but it was really just some minor formatting changes. It was not anything huge. It wasn't a major revision. And then in 1989, additional provisions were added. And they were things like bankruptcy. You know, we didn't really think about bankruptcy in the 70s and 80s as far as oil and gas companies. But when the bust hit, a lot of oil and gas companies went bankrupt. And so if you were the operator in that joint operating agreement and you were bankrupt, could you continue to be the operator? Well, there was no provision in the other forms to dismiss an operator. So in 1989, they came out with these additional provisions. They added additional definitions and to cover the types of situations that they saw. Now, so let's look at some of these new provisions. This was in 1989. And the 1982 Joint Operating Agreement had 8 provisions, definitions in it, and the 1989 had 18. And they include things like completion, deepen, plug back, recomplete, rework, what a zone is. They talked about the impact of bankruptcy on working interest owners. They talked about the rights and duties of the operators, including if they had the right to enforce a lien against the parties that were not paying for their fair share, what a deepening provision was. Then it established the order of preference of operations. What do we do first? What do we do second? What do we do third? And then how you handle paying wells. And then finally, it covered this issue that was not covered in the 56, 77, or 82. How do you get rid of an operator? And it's not easy. It still requires a vote. But we'll go over those provisions in a minute. So those were some of the changes that occurred as a result of the 1989 agreement. Now, the joint operating agreement that you'll see in Blackboard that you'll print out, you'll note is kind of an intimidating document. It is 20 pages in length, and it's legal-sized paper, front and back. And if you'll notice along the right side, let me see if I can access that. Show you what I mean here. Okay. So this is what I'm talking about, this AAPL JOA. This is one that I've created. It's still this 1982 model form, but what I've done is I've just gone in and made some annotations on the right side of it. So this is what it looks like. I'm just pulling this from Blackboard. Let's see if I can make this screen smaller. Okay, so that's the model form agreement. Okay, and then here's your table of contents. And this is what I'm talking about. If you look along the left side of the agreement, you'll see that there's numbers, 1, 2, 3, 4, 5, 6, 7, all the way down to 70 on every page. And the purpose of this is, instead of saying, well, I'm referencing Article 1A, and sometimes I have like, let's say I'm referencing Article 2A, Exhibit A, 3 percentages. Okay. Instead of doing that, what you can do is say, look on line 48. That's why they have those numbers on the side. So make sure that you take advantage of those, because that's going to save you a lot of time. On the right side is where I have kind of my little notes about what each of these provisions is saying. And we're going to be going over this in the class, but I just wanted to show you. On the regular joint operating agreement, this is not in red. So this is all black and white, but I'm just kind of highlighting certain sections of it so it'll be easier for you to follow along. So I hope that that is helpful to you. I want you to know that I am using this with permission from the AAPL. They are the ones that own this 1982 form, or all the joint operating agreement forms, but they have given me permission to use it for educational purposes. Okay, so does that help? Does everybody see how those line numbers really help? Now, if you look at the cover page of the joint operating agreement itself, you will see you get a lot of information before you even open the agreement. You can see that it'll tell you the date. It tells you who the operator is. It tells you what the contract area is, and then what county or parish or state it's in. So this is really helpful because it allows you to get a lot of information about the joint operating agreement right there on the cover page. So it's got the date, it's got the operator, and it's got the contract area. Now this may seem obvious, but the joint operating agreement also has a table of contents. And so from my experience, it's real easy when someone says, hey, is there a pref right provision in there? You know, you just get that paper and you just start flipping through it. Yeah, I think there is on this page. Instead of doing that, you know, use this table of contents. Okay, get familiar with it so you'll know what these terms mean, and then you can find, here's preferential right to purchase. Now we know, okay, we're just going to go to page 12. Believe me, I've done it many times where you just sort of hit the panic button and start flipping through this thing. But if you will take the time to use the table of contents, it's going to save you a lot of time and frustration. Okay, so those are the obvious things about the joint operating agreement. Now, the 1982 form is the most common form, and that's the form that I've given you in Blackboard. 1982 is the most commonly used form. So why am I highlighting a 1977 form? Well, the reason is you may be dealing with an old property, and that old property might be governed by a 1977 joint operating agreement or a 1956 joint operating agreement. So you have to be familiar with the different types of joint operating agreements. For example, I know if I'm looking at this 1977 joint operating agreement, I know there's not going to be a provision in there to get rid of an operator or to change operators. So I'm pretty much stuck with whoever the operator is that I have. If there's some kind of a bankruptcy situation and I'm in the 1977 form, I know there's not going to be a provision in there to cover bankruptcy. But most companies use the 1982 model form. That's been my experience. Do any of you, can you tell me what form y'all use? If you could just send me a chat on that. Let's see what kind of forms are being used out there. So even though the 1982 is the most commonly used form, you really have to be familiar with the different types of joint operating agreements because you never know what's going to be on an older piece of property. Okay, let me see what else I was going to tell you about it. Oh, they also have a 1989 form. And the 1989 form was designed to address the issues that came up with the 1982 form. A lot of people think that they just went too far with the 1989 form, and so they're sticking with the 1982. But it's really up to an individual company's discretion. So the AAPL has, all of these forms available for you if you want to use them. I think they have, they used to have a disc form that they would send you, and it would give you the joint operating agreement, and then you could just literally fill in all the blanks, and you would have the same model form operating agreement. Let's see, there was something else I was going to tell you about that. Oh, they're also working on a current one for horizontal drilling. That is in the works right now. It's not been released, but we're trying to add provisions to the joint operating agreement to cover those unique situations that come up with horizontal drilling. So stay tuned, more information to come. Okay, so now let's look at let's look at that table of contents. If you have it in front of you, please turn to the table of contents page. I believe it's the second page. And we're going to go over what is in this table of contents because you need to be familiar. If someone says, oh, I have a question about an operator, you need to be familiar that that's going to be Article 5. And when I teach a live class on this, I actually have a memory exercise that I use so that right off the bat you'll know what the 10 provisions are. I haven't figured out a way to do that on a webinar, but if you ever get a chance to come and see me speak on the joint operating agreement, in fact, I'm going to be in Midland April 9th and 10th, so maybe I can figure out a way to get you to attend that particular seminar. If you want to. It might be kind of boring because you've already been through it, but it's a really unique memory tip to teach you what the different provisions are. So Article 1 is going to be definitions. Article 2 is the exhibits. That's Exhibit A, Exhibit B, Exhibit C. 3 is interest of the parties. That is who owns what percent of the interest and who is responsible for paying what percentage of the bills. Titles is another whole section. This deals with, okay, you've got these different companies and they're each leasing their own properties. But what happens if there's a problem with the lease? Let's say there's a title failure or something. Who bears the responsibility for that? Who has to pay for those costs? Is it all of us or just the person that made the title failure mistake? And it also gives you some opportunities to talk about, well, how many days you have to get that title fixed. So that's what's covered in the title section. 5 is the operator. It states who the operator is going to be, and it states the responsibilities of the operator. 6 is called drilling and development. This is really the heart of the joint operating agreement. This is where you hear people talk about consent and non-consent penalties. So I want everyone to be crystal clear about what that is. When people are confused about the joint operating agreement, it's usually because they're confused about Article 6. So we're going to do a little exercise in the middle of the presentation. So you will be crystal clear with what those consent and non-consent penalties are. This is also where we talk about a back-end and a working interest situation. So we're going to go over Article 6, the heart of the joint operating agreement, in detail. 7 covers expenditures and liabilities. It gives the operator the authority to pay up to a certain amount without having to get the approval of the other parties. So it'll usually say, like, expenditures under $10,000, that's something the operator can just do on his own. Anything over that amount, you have to get approval from the other parties. Acquisition, maintenance, and transfer is Article 8, and that talks about if you want to transfer their interest. This is where the pref right comes in, preferential right to purchase. We'll cover that when we get to this article, but this is where this is a very important provision is in here. And then number 9 is the IRS. Just like when we talked about the farm out agreements, this basically says this is not a partnership. If it's a partnership, certain obligations are incurred, certain taxes have to be paid, and so we're very clear right up front in black and white in our agreement. We say, hey, IRS, back off. This is not a partnership. And then 10 is claims and lawsuits. So if during the course of drilling or at any point on the joint operating agreement we get sued or the operator gets sued, it says how we're going to handle that lawsuit. And basically it gives the operator the right to settle a lawsuit if it's less than a certain amount. Again, let's just use $10,000 as an example. If to settle the lawsuit will cost us $10,000 or less, the operator has the authority to settle that lawsuit. Otherwise, it's got to go up for a vote of the other working interest owners. Force majeure, that's just like in the oil and gas lease. If there's some provision that's beyond the ability of the operator or the other parties to control that prevents them from entering, from meeting their obligations, it's not going to cause this agreement to be null and void. 12 just says, hey, when you need to send a notice to somebody, like for a non-consent notice, here's all the addresses that we're going to use. Term says how long this joint operating agreement is going to be in effect. Compliance with laws says we're going to follow all laws, we're not going to discriminate, we're going to follow the laws of the state that we're in, etc. And then 15 lets them put in any other provisions, as does 16 with miscellaneous provisions. So that's kind of a big picture overview of what's in the joint operating agreement. So let's now look at these individual provisions. But before we do that, we have to understand why we have the joint operating agreement. You will recall that I've spoken about my family before and that we have 176 acres of land in St. Landry Parish, Louisiana. And right now my father and his brothers and sisters own it, but when my father dies, my father was also from a family of 7, he will get a 1/7 interest. And we will divide that 1/7 interest into 1/7 for each of us. We're going to really be rich here, folks. So the question is, all right, let's say that my brother Damien is approached by an oil and gas company, and he signs a lease with that oil and gas company. He doesn't get my permission. He doesn't get anybody's permission in this whole of his other brothers and sisters. But he has signed an oil and gas lease to lease his acreage. Can he do that? Can he give permission to an oil and gas company to come onto this land and drill a well? And the answer is yes, he can. Because every co-tenant has the right to develop their interest as is reasonable. And it's perfectly reasonable for someone that owns an interest, an undivided 1/7 interest, to want to develop that interest and to want to get their own, get monies off of that, even if the other undivided interest owners, the other joint tenants, refuse to do so. My brother can still have a well drilled on this land. That's why it's called an undivided 1/7 interest. It cannot be divided. So where can my brother drill on this 176 acres? Anywhere he wants. In other words, it's undivided. That means nobody owns the northeast. No single person owns the northeast quarter. We all own a 1/7 interest in the northeast quarter. Same thing with the northwest. Nobody owns the northwest quarter. We each own an undivided 1/7 interest. So because my brother doesn't own in a particular area, he can put that well anywhere he wants or anywhere that oil and gas company wants. That's what the co-tenant problem is. Now, is that fair to my brothers and sisters and I? And the answer is it depends. Because if we sign an oil and gas lease, let's say that we each sign with a different oil and gas company, those oil and gas companies are going to get together and they're going to form a joint operating agreement so that they can jointly operate this property. Okay, now let's say that only my brother Damien signs it. Are we going to be responsible for the payments? Are we going to be responsible for paying the drilling cost, my siblings and I? And the answer is yes, once payout occurs and you start making money. So my contention is going to be, well, you know what? You signed this oil and gas lease. I didn't sign it, and now I'm having to pay the bills. And his response is going to be, yeah, but you're getting paid money that you weren't getting before that way exceeds what the bills are. So it may sound like it's not fair at first, but the alternative would be that if you owned a 1/7 interest, you couldn't do anything unless you got everyone else to agree. And let me tell you something, in my family, that would be a real trick to get everyone to agree to do something. So that's why the law says, look, we want people to develop their acreage. We want people to be financially independent. And so therefore, we're not going to let one owner hold up any potential development of oil and gas in the area. What we will require is once payout has occurred, these people are going to have to start paying for their share of the bills, but they're going to be making more money than my brother was making because my brother is only getting a royalty interest and we're all going to be getting a working interest. So let me show you, this came out in a case called Earp versus Mid-Continent. This is the cornerstone case when we're talking about the joint operating agreement. It is a 1933 Oklahoma court case, and what happened was there was two owners, owner A, and I believe they were niece and aunt and nephew. Bear with me, let me get my tools here. So owner A owned a 2/33 interest. Okay, so they were a joint tenant, just like my 1/7 interest, but this is a 2/33 interest owner. His name was Claude Earp, and he signed an oil and gas lease with a company called Wagner. Okay, and that lease expires or will expire on November 1926. Owner B is Mary Earp. Mary owns a 31/33 interest, so she owns a much greater interest than Claude does. And she leases to Mid-Continent, and that lease is going to expire in November 1926 if there's no delay rentals paid or there is no royalties to be paid. So what happened is in July In July 1925, there was a producing well that was drilled by Mid-Continent. And in November 1926, Mid-Continent paid royalties to both owners, paid royalties to Claude Earp, who owned the 2/33 interest, and paid royalty to Mary Earp, who owned the 31/33 interest. Now, after that, even though Mid-Continent is continuing to pay royalties, Claude, who owns the 2/33, argues that his lease has expired. And instead of his net revenue interest being his 1/8 royalty times his interest in the well, his net revenue interest should be just a straight 2/33 interest. Okay, so let me Let me see if I can explain it more clearly. What happened was, let me go back one. Boom. Okay. So this owner A was Claude. He took a lease from Wagner, or Wagner took a lease from him. Owner B granted a lease to Mid-Continent. Mid-Continent drills the well and starts paying royalties to Claude and Mary. Now Claude says, wait a minute. It doesn't matter whether Mid-Continent drilled a well. Wagner, my lessee, did not drill a well. I have no obligation to Mid-Continent. Mid-Continent and I have no privity of contract. So what they're saying is, Claude is saying that this well that was drilled by Mid-Continent does not prevent his lease from expiring. His lease was with Wagner. If Wagner had drilled the well, then yes, his lease would have been prevented from expiring. But Mid-Continent drilled this well. Therefore, he should not have to be burdened by his 1/8 anymore, and he should get a straight 2/33 interest. Meanwhile, Mary Earp should get her 1/8 interest because it's her lease times her 31/33 interest. Is everybody with me on that? Okay, so in essence, what Claude Earp would be getting would be a 0.060606 interest, and Mary would be getting her 31. Oh, he would have been getting a 2/33 times a 1/8. But he's saying, hey, my lease expired because my oil and gas company, Wagner, didn't drill on the land. So therefore, I should only have to pay or get paid a 2/33, not reduced by this 0.125, this 1/8 royalty. So you see he's going to get a 0.04 more because his royalty amount is not going to, his his interest is not going to be diluted by the 1/8 royalty. Okay, that's the case, Earp versus Mid-Continent. Now let's see what the court said. The court agreed with Claude Earp. The court said if there's no contract between Wagner and Mid-Continent, then drilling by Mid-Continent is not going to save the leases of Wagner. It said in the absence of a contract to that effect, a tenant in common is not an agent for his co-tenants, and a lease executed by him is effective as to his interest only and ineffective as to the interest of his co-tenant. So there's no privity of contract between Wagner and Mid-Continent, and therefore Mid-Continent's drilling is not going to hold the Wagner lease. Now, this was revolutionary. This, people began to realize, oh my gosh, you know, in order for this well that was drilled by Mid-Continent to hold the other leases in the area, there has to be a contract between Mid-Continent and Wagner. So the court said only if there was agreement or a contract between the co-tenants, that is the oil and gas company, would drilling by one hold the lease of another lessee. So oil and gas companies began to go, okay, wait a minute. So you're telling me that in order for one well to hold all of the leases in an area, there has to be an agreement between the lessees? So just Mid-Continent doing this on its own is not going to hold the lease of Wagner? And the court said that's right. There has to be a contract between Mid-Continent and Wagner. Mid-Continent just cannot, or Wagner can't just sit back and let Mid-Continent drill their well. There has to be an agreement between the lessees so that one well can hold all of the leases in the area as long as those oil and gas companies had a contract together. And that's what started the joint operating agreement. The court is saying you have to have an agreement. Now, it could be a farm-out agreement. If there was a farm-out agreement between Mid-Continent and Wagner, we would have no issue here because there was a contract. But in this case, there was no contract between Mid-Continent and Mid-Continent. Mid-Continent and, oh shoot, who was the other one? And Wagner, sorry, Mid-Continent and Wagner. So in that case, this well would not hold the other lease, and in fact, Claude Earp then became another working interest owner, and he got a greater percentage than his aunt, who still was burdened by the 1/8 interest. Okay. Is everybody okay with that explanation? Are there any questions about that? I know that's a little bit confusing. But the bottom line is, once this case happened, oil and gas companies began to realize we have to contract with each other in order to protect all the leases. It could be a farm out, it could be a joint operating agreement. Whatever it is, the court here is saying in Earp versus Mid-Continent. And by the way, even though this was an Oklahoma case, it was followed in the other states. So that's why it's the cornerstone case. That's what other states also held. So it applies to all states. So now we have to have either a joint operating agreement or a farm out agreement or some kind of agreement between the working interest owners that would allow a well drilled by one to hold the acreage of another lessee. Earp versus Mid-Continent. Okay, so that's why then oil and gas companies started developing their own joint operating agreements, their own farm out agreements. And then in 1956, the AAPL came along and they said, let's establish a model form because this is the law of the land now. Let's figure out an easy, effective way for us to work together. And so they created the joint operating agreement. So now we're going to look at the specific provisions of the joint operating agreement. And if you want to follow along with the agreement or if you want to follow along with the slides, but the first article is definitions. And it will tell you what the different definitions are for drilling party, consenting party, non-consenting party, well, a reservoir. All these definitions are in Article 1. Article 2 says how the property is going to be distributed, and it gives what's called a contract area. What it does is it refers to something called Exhibit A, and it says the interests of the parties will be handled as it is set out in Exhibit A. This is an attachment to the back of the joint operating agreement. I don't think I included this. I'll have to check. I'm not sure I included. I'm pretty sure I included it on your form that I gave you. So what it does, this Exhibit A that's attached to the back of the agreement, is it spells out all the lands that are included in the area that's going to be governed by this joint operating agreement. And usually they'll attach a plat to it, a map, and that's usually Exhibit F. And then it says that the contract area includes all horizons. So it's got any depth restrictions will be, again, in Exhibit A. And then it gives the interest of the parties. First of all, in the initial well, the first well, it's going to be 50%, 15, 20, 0 before payout, and then after payout, it's going to be a different interest. And then subsequent wells, so any other wells, this is how they're going to be split out. So it handles who's going to pay what bills and who's going to get what kind of profit. And then it's going to outline what the different leases are, so these will be attached, and it will give any addresses for notification, like a non-consent notification. So Article 2 talks about exhibits, and the first exhibit that it covers is Exhibit A. That's where the critical information is about who owns what percentage. Also in exhibits, it's going to have what the lease form is. If someone is unleased, we're going to presume they're going to follow the lease form that's attached to the joint operating agreement as Exhibit B. Exhibit C is going to be the accounting procedures. D is to make sure everyone has the appropriate insurance that they need, especially the operator. E talks about gas balancing agreement. We're not going to go into detail about this. F, it says that we're not going to discriminate on the basis of race, religion, creed, etc. And G is establishing, once again, the all-important that we are not a tax partnership. Hello, IRS, back off. Then Article 2 says if there's any conflict between the actual provisions of the joint operating agreement and these exhibits, the provisions, the articles themselves prevail over any exhibits. So that's just a good rule of thumb to keep in mind. Okay, now Article 3, now we're on Article 3, so we're kind of whizzing past these. We're going to go through 10 articles here. Article 3 is going to be the interest of the parties, and it's going to set forth the oil and gas interest. And what it basically says is that the interest of the parties in cost and production are as they are split out on Exhibit A. And all parties pay their proportionate share of royalties up to a certain amount. Usually they'll fill in a blank here. It could be 1/8, it could be 3/16, but anything over that amount, I'll show you how that works in a minute. And nobody can transfer their property without an assignment. So again, because we're dealing with real property, it's got to be in writing. Article 3B, that was the oil and gas interest. Article 3B says the interest is going to be set out as it is on Exhibit A, and we're going to put in a number here. It might be a 3/16 or a 1/8 here. So let's say it's a 3/16. That means the parties are responsible. In other words, that the operator will pay all royalties up to 3/16. Anything over that amount is what's considered an excess royalty. Let's use 1/8 here, so that'll make it easier. So let's look at what this excess royalty is. Okay, so excess royalties are any payment in excess of that amount stipulated. So any payment in excess of that 1/8, for example, has to be paid by the party contributing that royalty. So if you grant someone a 3/16 royalty, you're going to pay the difference between 3/16 and 1/8. The operator will pay the 1/8, and you will have to pay any additional amount. The 1977 form said this was only for royalties. The 1982 says it also includes overrides and other payments. So if you give your geologist an override, that's something the operator is not going to pay. That's something that you are going to have to pay. That's called an excess royalty. So let's look at an example of that. So let's say all parties pay a proportionate share of royalties up to 1/8. So this is what we filled in that blank. So if you want to do the math, the lessee grants a lease with a 3/16 royalty. So what's written in that form is 1/8, but one of the oil and gas company give their lessor a 3/16. So the 3/16 is, the decimal is a 0.1875. All you're doing is dividing that 3 by 16 to get that number. To get the 1/8, that's what was inserted in the blank. That's a 0.125. So there's a difference of 0.0625. That means whoever granted this lease with a 3/16 is going to have to pay this difference. The oil operator will pay the 1/8, but the oil and gas company who gave the greater royalty is going to pay this 0.0625. So they're paying the additional burdens. Higher price basis, gross proceeds lease. That means you're going to have to, if it's a gross proceeds lease, that means you're going to have to pay, if you're the operator, you're not going to be able to deduct those costs from the landowner. Okay, let's see. Okay, so now this is subsequently created interest. Now we're still in Article 3, but we're under Article 3D. And what it says is that the interests are as they're stated on Exhibit A. If you create anything above and beyond what is stated on Exhibit A, you are responsible for those payments. So this is called subsequently created interest. And what it says is that if you create an override or you grant someone a production payment and it's not in Exhibit A, then you have to pay whatever those subsequently created interests are. And you can enforce this failure to pay with lien. So if they don't make their payments to their overriding royalty interest owners or those production payments, the operator can then force them to do so by putting a lien on their property. Okay, now we're at Article 4, and we're looking at individual versus joint losses. Just a little bit of law here. When we're talking about an individual loss, that means whoever could have prevented that loss pays for the damages. So in the case of a title failure, for example, if you were the party that bought the lease and you hired a landman who ran title incorrectly, that's your loss. You're going to have to pay for that, not the other working interest owners. A joint loss, a loss that everyone is going to have to pay their share of, is when the operator causes a failure. When it's the operator's fault that title failed, then all the parties are going to share in it. Now, why is that fair? Well, the reason it's fair is because no one would want to be the operator if they knew if there was something that they didn't do, like they didn't make a shut-in payment or they didn't make a delay rental payment. No one would want to be the operator. So we say, look, if you're the one that brought the lease and the lease is defective and title fails, that's your own fault. That's your own individual fault. But if title fails because the operator made a mistake, everybody has to pay for their share of that loss. So individual loss if it's your own leases, your own company's leases, joint loss if the operator causes a title failure to occur. Okay, now we're into titles. And first of all, you've got to have a title examination. The joint operating agreement says it's got to be required prior to drilling and that everybody gets a copy of the title opinion because everybody's paying for the title opinion. And who's going to bear the cost for the title opinion? Everyone does. Now, they do give two options. You can pay for the title opinion cost as part of the overhead, and you can check that box, or option 2 is paid by all the parties per Exhibit A. That means distributed the way it's stated in Title A. Title curative, who provides the title curative? Well, every oil and gas company provides their own title curative to the title attorney. In other words, the title attorney is going to say, we need an affidavit of heirship here. Who's going to provide that to them? Whoever took that lease is going to provide that title curative to the operator. The operator handles the regulatory agency, so they handle getting the pooling permit and those types of the well permit, the pooling permits, etc. If there's a loss of title, okay, you took a lease that was a bad lease and you basically don't have that lease anymore. Under the joint operating agreement, we're going to give you 90 days to go knock on that landowner's door and beg them to give you a new lease. And because it's your own lease, you're going to be responsible for all those costs. So if the lessor wants more money, that's not going to be a joint cost split out according to the joint operating agreement. You're going to have to pay for that cost. And then if you're unsuccessful, we're going to have to revise your interest in the joint operating agreement. If you're successful, we'll just leave your interest as it is. But the bottom line is you can't charge other owners to defend your title if you've got a problem with your title. If there's a loss by non-payment or erroneous payment and it's the fault of the operator, then all parties share in that loss. But if the loss is because you didn't pay a rental, then that's going to be an individual loss. Okay, so now we're with titles, and now we are moving on to Article 5. Article 5, this is again on the cover sheet. It says who the operator is going to be, and then it designates what the responsibilities are of the operator. The operator is in complete control of the operation. They are the ones that control who gets hired, who gets fired, and all the decisions that occur as you drill a well. Article 5B is how to remove an operator. Remember we said that in the 1977 form and the 1977 form and the 1956 form, there was no provision for removal of operator. So this says there's a vote that occurs and it gives you the process for selecting a successor operator. It is not easy to remove an operator under the terms of the joint operating agreement, nor should it be, because that's just going to create chaos. And if you're the operator, you've already incurred some expenses, and so we make it a little bit difficult for you to remove that operator, but still you can remove it whereas in other joint operating agreement forms you could not. And then it says how to select the successor operator. The operator is in complete controls of the employees. They can hire, they can fire. They are also in complete control of getting drilling rigs and paying for the drilling contracts, and they can even be their own drilling contractor as long as they're paying what the market is. So they can even hire their own company to be the drilling contractor and charge the other joint operating agreements as long as that drilling contract is similar to what other drilling rig operators would charge in the area. Okay, still at operator powers, I just wanted you to see what this looked like under Article 5, operator, and here on line 4, it states who the operator is. Blank shall be the operator of the contract area and shall conduct and direct and have full control over all such operations. And then down here it says the resignation or removal of operator and selection of successor. Now, we are at Article 6. This is the heart of the joint operating agreement. Once you understand Article 6, you understand the joint operating agreement. You get the gist of it. Everything else is just reading it. But this is what's difficult for people. This is what's confusing. This is what's intimidating. And it is what's called the drilling and development, or more commonly referred to as consent and non-consent penalties. So what Article 6 says is that for the initial well, the first well that we drill, everyone has to pay their fair share. You can't opt in, or you can opt in, but you can't opt out of that first well. So everyone is in for the first well. So I want you to take something on your desk. Maybe you've got some paper clips there, some binder clips, or little pieces of paper, whatever it is. And I want you to take one of those paper clips and put it in the middle of your desk, just to give you an idea of now you are paying for your fair share of the initial well. So everybody pays for their fair share, and you drill the well, and yes, the well is successful. So now I'm throwing more paper clips at you. You all just made a bunch of money because that first well was successful. Now, any other party can then propose another well. Any other party in the joint operating agreement can say, hey, I have an idea. Why don't we drill a well here? I mean, that one was really successful. Let's drill the well here. And they can propose that. They can send a notice to the other working interest owners. Why don't we drill a well here? Anyone can propose that. Okay, so let's say that I propose that we drill a second well in the northwest quarter. What I would do, if you were a working interest owner, I would send a notice to you and to the other working interest owners, and I would say, hey, this is where I want to drill a well. I would send you the map. I would send you the plat. I would give you my reasons why we should drill the well. You then have the option to either consent, which means opt in, or non-consent, which means opt out. So again, we're not talking about the initial well. The initial well, you can't opt in or out. You are in. You sign that joint operating agreement, you are in. That is expressly stated in the joint operating agreement itself. But any subsequent wells that someone else proposes, or even the operator proposes, you can decide whether your company wants to pay those costs or and reap the benefits of a successful well, or not pay those costs and sit back and see how the well does. This is called non-consent penalties. So this is the way it works. First of all, very clearly it says, I usually get a question when I teach this, well, everyone doesn't have to be included in the first well, do they? Unless this provision is modified, yes, they do. It says, on or before the blank day of blank year, the operator shall commence the drilling of a well for oil and gas at the following location and shall thereafter continue the drilling of the well with due diligence to this formation. But it's when there are subsequent operations. This is called proposed operations. This is Article 6B1. Article 6B1 says that if any party wants to drill another well in the contract area, then they have to notify the other working interest owners. And here's some key language. And the other party shall have 30 days once they receive that notice to let you know whether they're in or whether they're out, whether they're consenting or whether they're non-consenting. If they fail to reply within the period above fixed, that means they are electing to not to participate, to go non-consent. Okay, now let's look at what these non-consent penalties are. Now we call these penalties. We call these penalties, but what I really want you to think about it is what I really want you to think about these more as we're trying to reward the people that took the risk. Okay, so instead of thinking of it as a penalty, which it's called a non-consent penalty, think about it more as we're rewarding the people that took that risk, that said, okay, yeah, I'm in. I'm going to pay for all of the cost of this. Okay, so if you agree, all right, take another paper clip and put your paper clip in. All right, now let's say we've got some people that have decided that they don't want to participate. Let's say I'm going to pick on Karina and Yvonne here. And they said, you know what, our geology does not support this. Our management says we should not participate in this well. So we're going to opt out. Okay. So now let's say the interest was, let's say the interest was 33 1/3 for Karina. No, let's do quarters. Okay. 25% for Karina, 25% for Yvonne. Let's say I'm the operator and I have 25% and you have the other 25%. Okay. So you come along and you say, hey, I have an idea. Let's drill a new well here. You send out your notice to the other parties. And I say, yeah, I think that's a great idea. And Yvonne says, yeah, I think that's a great idea. And Karina says, no, I don't think I want to participate in that. Okay. Now we have, and of course you're in because you were the one that proposed it. So now we only have 75% working interest. So only 75% of the bills are going to be paid. Someone has to take Karina's interest. Okay, so let's say, Yvonne, you take 12.5% of her interest, and then I'll take the other 12.5% interest. Let's say everyone says, no, we don't want to take her interest. That well is not going to get drilled because we can't pay for 100% of the cost. So when someone opts out, someone's going to have to pick up their share of the interest. Now, when you opt out, so now let's start this over. So now let's see, Yvonne is in. So we've got Yvonne over here, we've got me here, and we've got you here. Okay, and we are splitting those costs. And then let's say that well becomes a huge producer. That well immediately, Yvonne, me, and you are going to get a huge, whatever the profits are. Big profits, big money. Karina, because she non-consented, she's not going to get any of the profits of this until the well pays out. And we're not only going to make her wait till the well pays out one time, that means all of the costs of the well are reimbursed. We're going to put a penalty in here of 300%. Now, I've seen this anywhere from 300 to 500%. And what it says is, before Karina gets any of the profits of this well, that well has to pay out one time. We've recouped all our monies from the well. Then it has to pay out a second time, meaning we get double of what we paid in. Then it's got to pay out 3 times. So 3 times what the well cost. Then and only then, if it's a 300% penalty, does Karina get to come back in and recoup her share, her 25%, and then we each go back to our 25% interest. Okay? So Karina is not getting anything if it's a 300% until the well pays out one time, the well pays out 2 times, the well pays out 3 times. That means we've recovered all our costs times 3. Then and only then does Karina come in. Now this could be 500%. And if it's 500%, the well has to pay out 1 time, 2 times, 3 times, 4 times, 5 times before Karina gets anything. Now, are we trying to punish Karina? No, what we're trying to do is we're trying to reward the people that took the risk. Because of this well, the subsequent well was a dry hole. How much would each of these parties have to pay? Well, Yvonne would have to pay 37.5% of the cost. I would have to pay 37.5% of the cost, and you would have to pay your original 25% of the cost. What does Yvonne have to pay? 0, because she non-consented. So we'd be out money, and she's not going to be out the money. So that is why it's called a non-consent penalty. But think of it as rewarding these folks that agreed to stay in. That is what the purpose of it is. So that is the Article 6, the heart of the joint operating agreement. As I said, once you understand this, you understand the joint operating agreement. Consent, non-consent. Drilling party, non-drilling party. Consenting party, non-consenting party. Those are all the terms that you will hear people use to refer to these non-consenting penalties. But that's basically what it is. For any subsequent well, you can opt in or out. If you opt out, you're going to have to wait before you get a share of the profits. That's all it is. Now, let's look at liability of the parties here. This is Article 7, so we're moving along. And what it basically says is that there's two types of liabilities in the law. One is joint. That is, all their parties are responsible for the liabilities of the other. Several means that the liability is severed. Several liability means the liability is severed, so that if one person gets sued for sexual harassment, okay, let's say owner A gets sued for sexual harassment, and there's 4 owners. A gets sued for sexual harassment. If A goes bankrupt and the liability is joint, that means they can then sue B, and they can sue C, and they can sue D, because we're all responsible for the liabilities of each other. But if it's several liability, it's severed. So A made the mistake, A was sued, only A is liable. So that's why a lot of times they'll put that the liability in a joint operating agreement is severed. We're not going to be responsible for your sexual harassment charges. And this may sound far-fetched, but on drilling rigs out in the Gulf of Mexico, you know, where everyone's bunking together, this is a big issue. And so there are a lot of complaints about sexual harassment, even though they're all men together, but there is typically there's no women on board, but there is, you know, claims of sexual harassment. And so we want it to be against the person that, you know, whose company committed this act of sexual harassment, not all the other parties. Okay, now you can have the option to, option 1 is once you've consented or non-consented, or if it's the initial well, you can agree to pay all necessary expenditures for any drilling, deepening, testing, or recompleting a well. That means once you've agreed, once you've consented, once you've signed that agreement, if it's the initial well, you're going to be responsible for paying any costs associated with that well. Option 2 says, well, it's called the casing point election. That means, wait a minute, when we get to the point where we're going to decide whether to put casing down the well, at that point we can decide whether or not we want to continue with the well or to opt out of the well. So a lot of companies will check this casing point election because they don't want to be committed all the way down. They want to wait and see what kind of well data comes out from the well logs to see whether they want to continue. Now, if we're talking about horizontal drilling, option 2, there's no casing point election. You're in, you know, once you opt in, or if it's the initial well, once you sign the agreement. Okay, I'm going to go through the rest of this briefly because once you understand the heart of it, this is all just extraneous. But what it says is that the operator can undertake any single project. It gives them the authority to you know, deepen or do something to the well as long as it's less than this certain amount. Maybe we'll put $10,000 here, okay? And anything above that amount, we've got to get permission from the other working interest owners. Claims and lawsuits, Article 10 allows them to set a dollar amount for settling a lawsuit. Usually, again, I see $10,000 here. If the operator can settle the lawsuit for $10,000 or less, he doesn't need to get permission from the other working interest owners. And that concludes our presentation on the joint operating agreement. So what we looked at was an overview. I gave you a basic definition of the joint operating agreement. We talked about the different forms of joint operating agreement, the 1956 form, the 1977, the 1982, and the 1989, and we talked about what those distinctions were. And then we looked at alternatives to the joint operating agreement. Specifically, we looked at the co-tenant laws, and we looked at that critical cornerstone case called Earp versus Mid-Continent that says just because one lessee drills a well, there is no privity, and there's no privity of contract with the other lessee, that well will not hold the leases for the other leases in the area. And then that gave us the opportunity to look at the contract itself, which is a 20-page legal size document, tiny 8-point font print, and wanted to remind you to look at the table of contents and to look at those numbers along the left side and to use that AAPL form guide that I gave you. I hope that will be helpful to you. And then we looked at all the clauses of the joint operating agreement, paying specific attention to Article 6 and the consent and non-consent penalties. Very important to understand. Once you understand that, the rest of it is just basically reading. I do want to mention something called the preferential right to purchase. That is a clause in the agreement that says if you decide you want to sell your leases or you want to sell your acreage, you have to offer it to the other parties first. That's called the preferential right to purchase. And the reason we have that clause in there is because we don't want to be basically business partners with people that are not reputable. So it gives the other working interest owners in the joint operating agreement the option to purchase it first before you sell it to some yo-yo. You have to offer it to us first. Now, many an acquisition and divestiture has come to a screeching halt because the division order analyst has said, wait a minute, there is a preferential right to purchase in this agreement. And it really then, they were about to close on the deal, and then they had to stop. They had to send a mail out to the other working interest owners offering it, and it delayed the process. So a lot of times now you'll see this provision struck. The preferential right to purchase is struck. But you need to pay attention to it, because if it's in there, you need to offer it to the other parties first, or you will be in breach of contract. Finally, the joint operating agreement does not have to be recorded. It does not have to be recorded. However, a lot of people often record what's called the memorandum of a joint operating agreement. That is just a paper that says that there is a joint operating agreement established in this area by these parties. And it's a one-page sheet. It doesn't give you all the details about the joint operating agreement. And the reason we do that is because the operator has the right to file a lien against someone who's not paying their bills. And the only way they can enforce that lien is if the joint operating agreement is recorded. So even though it's not a conveyance of land per se, because we want to enforce this lien, a lot of companies will go ahead and record at least a memorandum of the joint operating agreement. So I hope this was helpful to you. Are there any questions? Good question. I have a question that says, I may have missed this, but how is the operatorship determined? Usually the operator is the person that has the most leases will become the operator. Now, if they opt out, the parties can then vote to determine who the operator is. But generally speaking, it's the person who has the most leases. Good question. Any other questions? Okay, well, I thank you for attending this webinar, and I look forward to seeing you in the next one.